Hi friends, in this video we will be discussing the recent judgment issued on 9th February 2024 in the case of Prahitha Construction Private Limited by the Telangana High Court. Again, why this is very important judgment because it is on the issue of transfer of land development rights. Probably this is the first judgment under GST which has come on this topic, and hence this is important. First, I'll take you through the facts of this case. There were two land owners who entered into a joint development agreement, the JDA, with a developer called Prahitha Construction for a development of a property in Telangana. The developer went to the High Court asking whether this land development rights are taxable under GST or not, because it is a belief in with many of us that this is nothing but a sale of land. The High Court, after extensively going through the clauses of the JDA, the agreement between these two persons, ruled in against these petitioners. The court has dealt with the clauses of the agreement very extensively, as I said. Particularly, there is a clause in the agreement which gave the right to the landowners to cancel the agreement in case the developer defaults or delays in executing this project. So the court said that if the ownership or the title on the land has not passed on to the developer, then it cannot be a sale of land. Second argument that the court took was that the developer and the landlord enter into a conveyance deed with the original or the customer of the unit that the flat or the office that they were constructing. There was no conveyance deed between the landowner and the petitioner. So, and the main argument of the petitioners was that this is a sale of land, and a constitutional argument that this is not in the purview of GST, constitutional. I don't think there were any other arguments that the petitioners present, at least from the text of the judgment it seems so. Now the court has held as under. Landlord has a bundle of rights attached to the land. One of them is getting the land developed. JDA has a clause which deals with the situation where the developer delays in completing the project. The landowners have a right to cancel. Landowner and developer will convey the land to the unit buyer. There is no conveyance between the developer. Hence, JDA doesn't result in transfer of ownership. There is a barter transaction between the both. Now, this was not argued against by the petitioner, that there is no barter happening here. The landowner does not give anything to the developer, or the developer does not give anything to the landowner. These both get together and give something to the customer. But this argument seems to have been missed. This judgment, in my belief, is peculiar to the facts. So it cannot be considered as a precedent for all the other TDR or FSI transactions. That is my personal belief. Many legal issues have not been brought to the notice of the court. And it is a well-settled principle that the judgment is as good as the arguments presented. The court cannot rule on the arguments which were never presented to the court. So this judgment, in our belief, is limited to the facts of the case and cannot be applied for all the cases. So still there is a fight to be fought. Hope the petitioners in other such cases will bring out all the legal issues surrounding this very, very important facet, because the entire project, if the tax is levied on TDRs and FSI, the entire project goes tax heavy. And for the developers, it becomes unviable or unfeasible sometimes to financially execute such projects. And we also urge the government to issue some clarification and reduce the cost of tax if they deem that this is taxable, so that the projects become viable. I hope this video is useful to you. Thank you.